हेलो एवरीवन। अगर आप लॉ में इंटरेस्ट रखते हैं या फिर लीगल अफेयर्स में, तो ये आर्टिकल शायद आपने एक आध बार देखे होंगे, जहाँ पे ये बताया जा रहा है कि इन केस ऑफ आर्बिट्रेशन, और आर्बिट्रेशन का जो अवार्ड होता है, जजमेंट, बट आर्बिट्रेशन के केस में इसे अवार्ड बोलते हैं। तो आर्बिट्रेशन का जो अवार्ड है उसमें सुप्रीम कोर्ट मॉडिफाई कर सकता है या फिर कुछ लिमिटेशन है। इट कैन मॉडिफाई बट देन देयर आर सर्टेन लिमिटेशन। बट सच्चाई कुछ अलग है। सच्चाई कुछ इस तरह से है, ट्रेडिशनली जुडिशरी का जो रोल रहा है, इट ऑलवेज स्टूड फॉर द फ्लैग ऑफ जस्टिस। इट स्टूड beneath all those principle of natural justice, the principle of judicial review, the supremacy of the law, and all those things. But now the role, the flag is shifting or changing. Now it will more be an observer or an administrator of so-called justice. And if you want to understand this truth, I would highly recommend that you read this judgment, Consolidated Construction versus Software Technology. ये 28 अप्रैल का जजमेंट है, आप इसको पढ़े, आप समझ जाएंगे that moving forwards, it is not going to be the principle of natural justice or the principle of judicial review or the supremacy of the law or the principle of legal spirit. These are not going to be the factor that decides an outcome of a litigation. It is going to be a very different form of litigation. Now, whether that is a good or bad, that's a different question I'm not going to get into. But certainly, it is not going to be the principles of justice, and it's not has nothing to do with this. So this new advocacy has nothing to do with the justice. Now, coming to the key, the topic of this session है the rise of arbitration and the fall of judiciary. A legal critique of Section 34. Now, the Section 34 is the main important part, and if you know what Section 34 does, and you know how this entire how international laws and all this arbitration works, then I'm sure this session is going to be quite informative or a novelty. Now, the first thing you need to kind of summarize or recapitulate that what is arbitration. Now, arbitration भी एक litigation, एक तरीके का litigation है, but इस litigation का जो main sum and substance होता है या फिर जो main driving force होता है, that is the contract. So दो commercial entity में जब वो दोनों arbitration में जाते हैं, so it is not the constitution, it is not the principle of natural justice or CPC, laws of the CPC, or the principle of judicial review that is going to dictate the procedure. It is the contract. Whatever is there in the contract, the arbitrator जो भी रहेंगे या फिर mediator जो भी है, he is only going to interpret the contract. So they are not going to read the principles of the constitution, the principles of democracy, and all these other important factors of democracy and the justice. So its role is very much confined. Now, though there is a presumption कि arbitration जो है वो commercial matter है, but अगर आप थोड़ा सा इसको deeply सोचेंगे, gradually every aspect, even employee और employer का जो relation है, that is also becoming a contract based service. तो वहाँ पर भी अगर arbitration का clause डाल दिया जाए, so then you will also become part of this arbitration procedure. When you become a procedure, so it's not going to be the principle of, again, the natural justice, but rather whatever is there in the contract आपको वही मिलने वाला है. The arbitrator cannot go beyond the contract. So again, it's mere just an administrator, or rather a legal enforcer. Just enforce करना है तो किसी को तो रखना पड़ेगा administratively. So that's the only job that they are going to play. Now, why this Section 34 decision is important? Now, historically, or even now also, Section 34 is basically a bridge or a tunnel that allows a litigator to bring its litigation from the domain of arbitration to the domain of a principle of natural justice or principle of judicial review. But now onwards, that is not going to be the case. So that bridge, the historically the bridge that used to be there, that bridge has been destroyed by yesterday or day before yesterday's constitutional meeting. और मैं इसको मीटिंग इसलिए बता रहा हूँ, 5 बेंच जजेस के मीटिंग थे स्टेट सेंट्रल के स्टेक होल्डर्स के साथ, इसलिए बिकॉज now since the concept of justice is no longer exist, it is just a meeting, administrative meeting. Let's just stick to you know plain simple honest language. तो इस मीटिंग में जो भी हुआ, now that bridge is gone. now अभी जो ब्रिज है, इट्स अ वेरी नैरो ब्रिज, और ये ब्रिज का जो रोल है बहुत स्पेसिफिक है. एंड दैट स्पेसिफिक, एज आई बीन सेइंग, इट इज़ द रोल ऑफ एन एडमिनिस्ट्रेटर. तो अगर कोई एरर है, कोई डिस्प्यूट है, डिस्प्यूट एरर मतलब क्या, सही से नोटिस सर्विस नहीं किया गया है, अग्रीमेंट कुछ गलत है, पब्लिक पॉलिसी के अगेंस्ट है, या फिर जुरिस्डिक्शनल एरर है, तभी जाके आप सेक्शन 34 इन्वोक कर सकते हैं, अदरवाइज नहीं. अगर आपको लगता है कि आपके साथ इनजस्टिस हो रहा है, आपके साथ गलत हो रहा है, जो हो रहा है दैट इज नॉट फेयर, द रीजन इट इज नॉट रीजनेबल, यू कैन नॉट ब्रिंग और इन्वोक सेक्शन 34. मतलब आप आर्बिट्रेशन से इसको जुडिशियल रिव्यू में नहीं ला पाएंगे, क्योंकि again, anthropologically or historically, judicial review had many pillars, starting from the principle of natural justice, principle of equity, the equality, the fairness, the values, the ethics, the reasoning, the rationale. All these things were there to support the concept of judicial review. But now all these things have been dispensed with. Now they will only do administration or supervise. Basically, will be a supervisory role. And as I said, it will just be interpretation of the contract. तो आपके contract में जो भी लिखा हुआ है, it is going to interpret that only. It cannot go beyond those written words and the sentences. So, the conclusion from justice to contractual logic. Is it going to be good or bad? That I'm not going to, again, I'll not talk about. But what I'm going to say is this. This will have a new era of advocacy. शायद एडवोकेट्स के लिए बहुत अच्छा हो, बिकॉज नाउ द कंपनी जितने भी है, दे विल स्पेंड लॉट ऑफ रिसोर्सेज इनटू दिस contract drafting, negotiation, and everything. So it's not going to spend now, at least up until now, most of the companies, when they go into some sort of contract, that often they are careless about the contract. And you can again read that judgment that I referred in the beginning. आप समझ जाओगे कि एक सिंपल एरर उनके कॉन्ट्रैक्ट के वजह से उनको 80 lakhs का कैसे घाटा हुआ. So now moving forwards, companies will be very conscious about it, and they will spend a lot of attention to it. So they have to bring a lot of lawyers and the advocates. जुडिशियल इंटरप्रिटेशन बहुत सारे जजमेंट्स है. देर इज ओनली वन एलिमेंट जो पब्लिक पॉलिसी का, बट देन दिस थिंग रियली डजंट मैटर. क्यों? क्योंकि पब्लिक पॉलिसी का जो है दैट इज अ वेरी बेसिक सेंस. व्हेन अ कमर्शियल एंटिटी, जैसे सोचिए इंडिया में कोई कमर्शियल एंटिटी बिजनेस कर रहा है ना, देर आर सर्टन लॉज आर इन प्लेस, बट डेफिनेटली इट विल नेवर डू एनीथिंग. जो बिजनेस जो भी लाएगा वो कभी ऐसा कुछ नहीं लाएगा जो पब्लिक पॉलिसी के अगेंस्ट है. ये कॉमन सेंस है. और द बिजनेस नो ओनर्स or the institutions, they are way past this public policy and all that. Judicially, the alarming part is actually the role of judiciary, that it's shrinking over the years, and it is shrinking probably since independence. uh, Trial court doesn't know what its job. The high court is now with limited jurisdiction, merely administrative or supervisory role. So the notion of justice seems to be, or it is going to be, a thing of the past. Future kya hoga, that's only time will tell. But certainly the conventional role of judiciary will no longer be there. Now, arbitration, a commercial tool hai, as I said, it certainly has its pros. It has a lot of positivities, speed, efficiency, confidentiality. A lot of things can be brought under arbitration. However, there is a cost that's involved in arbitration, and the new in the coming days, in this new paradigm with the limitation in section 34, the companies or any individual or any entity who is signing a contract need to be really careful, and this contract is going to be the future. So one really has to pay attention to the contract whenever it comes to contract. Implication is, I do not know. I mean, what will implication? The one thing, as I said, we have to, you know, have to divorce ourselves from the traditional concept of justice. So all this big talk about principle of natural justice, judicial review, the equity principle, all these have to take the back seat, and now it will always be the critical analysis of contract, or the based on economic affairs. So you need to follow the commerce. I think somebody once said that if you want to become a good lawyer, you always follow the you follow the commerce, because they know laws better than anybody actually. And that is one of the reason why you will see that most of the companies heavily invest on CAs and other special individuals, because you require those individuals to get past these you know legal barriers, whatever the state is putting there or trying to put. द वे फॉरवर्ड इज सर्टेनली, जो न्यू एज एडवोकेट्स होंगे, बहुत अपॉर्चुनिटीज़ आएंगे, बहुत अच्छे भी होंगे इसमें, मेरे हिसाब से. बिकॉज इफ़ यू लुक एट हाउ at this moment Indian judiciary is functioning, people are not at all very happy. And I think The only matters in coming days that judiciary will be handling will be those, thief, maybe the dacoits, the murderer, the rapist, or those marital dispute matters. But that's where I think uh, its venture will be not beyond that. And contract drafting is certainly is going to be new profession, and I think already there is a lot of shouting in terms of be able to learn good contract, a well thoughtful contract. Certainly that's going to be a new area that new lawyers and advocates they can try and master. If you ask me the question, is the judiciary will be able to bounce back? Certainly no, because in last 70 years it hasn't been able to bounce back in any manner. It only seems, retreating its back from farther to the farthest. So I'm not going to be optimistic there. I mean, unless you are irrational or a person who, what would you say, pessimistic, but just as pessimistic, then it's a different story. But otherwise, definitely no. So that's everything for this session. I would invite some comments, आप लोगों का कोई भी, and hopefully someday maybe we can have a debate on this one, on this new era of advocacy that is emerging or that has emerged after this decision. Thank you.